So this is the relevance of Balakrishnan report, and I will read it at the end using my discretion not to read which is not relevant, but to say that Balakrishnan committee report should be discarded may not be a correct assistance to the court. My Lord, I am not relying upon, my Lord, I at the outset, my Lord, point out that wherever word state is used, union territory is outstate, that part of the commission I am not relying upon. That, my Lord, the Chief Justice of India has taken care, my Lord, in the Constitution bench. It has to be decided contextually, but to give context to the word insofar as it is applicable to union territories. Lord, your Lordship would examine whether a particular matter, Constitution doesn't use the word entry, particular matter is applicable to union territories. It's not in singular, it's in plural. Can Lakshadweep do that? Can Dadra and Nagar Haveli do that? That is the context. Lord, with special context with regard to Delhi, emerging from the Balakrishnan committee report. That complete control for various reasons. Lord, there has to be a lieutenant governor who is informed by the officers. Lord, nobody say the bureaucracy should be pliable bureaucracy. Lord, I personally had a very serious objection, though it was lightly said, monogamy, that permanent monogamy. No, bureaucracy is not wedded to any party, any government. Bureaucracy is wedded to the Constitution of India. But suppose national capital is under a siege. You take an example. National capital is under a siege. One arterial road, my Lord, linking one section of the country to the capital is blocked with permanent structure. And if the government of Delhi sends food, it is the responsibility of the bureaucrat to inform the LG that this is the capital cannot be under the siege. That is the control, my Lord, which is envisaged under 69th Amendment. If during the COVID period, the number of tests are brought down, my Lord, with a view to ensure that the figure is good, it would affect, my Lord, the future course of action the country would take nationally. The health secretary will have to bring it to the notice of the LG. That you cannot do that. At a particular point of time, the test has to be rigorous testing so that we know the real problem, whether we are dealing with a rat or with a dinosaur, so that the national policy can be accordingly framed. If we show only 10 persons are affected with COVID, though there are 500, Lord, we may have a situation where all high commissioners and ambassadors are affected, and the world over the message will go that the government of India is doing nothing. It is the national shame. Look, therefore, I am not saying the bureaucracy should be loyal to the central government, but the central government must have a say. Who will be appointed and who will head which department? Then, as I have shown from the terms of business, he is bound by the transaction of business rules. He is reporting to the minister. He is taking orders from the minister. He is bound by the instructions of the minister. If there is any difference, it goes to the Council of Ministers. Council of Ministers is supreme. Collective responsibility, democratic functioning, everything is, my Lord, I respectfully bow. But to say that once the officer comes under my jurisdiction, it's my decision what to deal with, how to deal with him, and what to tell him, that goes against the very spirit with which 239AA is introduced. Lord, now kindly, my Lord, see, my Lord, page 34, your Lordships can just have a look. These are the judgments why the report which becomes the basis of a constitutional amendment is a good external aid for interpretation. I am not, my Lord, reading it. Now, my Lord, your Lordships may come to 35. Your Lordships have read and reread Article 239AA, but it would take 5 to 10 minutes, my Lord, if your Lordships allows me to read it, and your Lordship reads it with me, the way, my Lord, I perceive 239AA to be, which, my Lord, gives the supremacy, not only to the Parliament, but to the executive as well, because the executive function is always coterminous with the legislative function of the executive. Lord, where 35.
Mr. Solicitor, instead of reading that, if you can just look at your para 67.
Yes,
You have highlighted some very important aspects of 239A. So we
Yes.
can read para 67 actually. Because you have paraphrased which are those parts of 239A which are crucial according to your submission.
Yes, Lord. Only one thing before that, with my Lord's permission. May I read 3A only first and then come to 67?
Yes, all right. We can read
3A at 35.
Yes.
Subject to the provisions of this constitution. Kindly pause here for a minute. Lord, this includes sub-article 1 also, which reads, as from the date of commencement of the Constitution 69th Amendment Act, the Union Territory of Delhi shall be called National Capital Territory of Delhi, and the administrator thereof appointed under Article 239 shall be designated as the Lieutenant Governor. So, my Lord, 239, original 239, which was brought in under the 7th Amendment, is applicable. Administrator does govern the Union Territory. And your Lordships have accepted in the Constitution by this. 239 existed much prior to 239AA, which empowered administrator to control or to administer the national capital, all Union territories. So that continues because it is subject to the Constitution, and which includes 239 and includes 239AA sub-article 1. Then, my Lord, further, 3A. I'm sorry.
Yes.
No, my lords are jotting. The Legislative Assembly shall have power to make laws for the whole or any part of the National Capital Territory with respect to any of the matters enumerated in the state list or in the concurrent list. Please mark, insofar as any such matter, not any such matter is applicable to Union territories. Lord, plural. So the test in my respectful submission for your Lordships would be a subject matter wise selection of implied exclusion. Lord, there are two exclusions under this. First is, my Lord, insofar as any such matter is applicable to Union territories. That is implied exclusion contextually, as my Lord the Chief Justice of India has read, and I'll show my Lord, those paragraphs from the judgment. That is implied exclusion from the subject matter. That this subject matter can't be in Union territories, and when you Lordships test, it has to be whether Lakshadweep can do it, whether Goa, whether Div and Daman can do it, whether Andaman and Nicobar can do it. That would be the test. And second, except matters with respect to entry 1, 2, and 18, and so and so. Now B. Now, Lord, kindly come to 37. My Lord Chief Justice of India, my Lord, very kindly indicated, para 67. A perusal of Sub-Rule 3 would show that the extent of legislative powers of the Legislative Assembly of NCT is consciously, unequivocally, and manifestly circumscribed by 5 modes. A. My Lord, I have already pointed out, subject to these provisions of the Constitution. That is, administrator, governor Union territory continues. And 2. The legislative power of Delhi Legislative Assembly to be be it under state list or in concurrent list is circumscribed to the extent insofar as any such matter is applicable to Union territories. So, my Lord, in other words, the legislative power of Assembly cannot extend to any of the entries in the state list or concurrent list if the state entries are not applicable to Union territories. It does not use the expression in relation to Union territories. It says applicable. My Lord, applicability test is a rigorous test. It should be applicable. Relating to is a lesser.